good morning, and welcome to the final round of the 57th Annual Roger J. Traynor Moot Court Competition. My name is Miriam Billington. I'm the administrator of the Traynor, and this is how the session will work today. I'm about to turn over the proceedings to our esteemed bailiff, who will introduce our panel. At the end of the argument, the justices will confer offline in real life, and then I will return during that break with some thank yous and awards. Then the justices will return to the room, offer their comments, and announce the winner of this year's Traynor. Acting as our bailiff this morning is Professor David Glassman, a decades-long supporter of this competition. For the purposes of this session, David Glassman and I are not affiliated with either team competing here this morning. So we thank you, and I am now turning over the proceeding to you. Please unmute yourself, bailiff.
Thank you.
Okay.
Welcome to the final round of the 2026 Roger Traynor Moot Court Competition, the case of the people of the state of California versus Peter Prescott. Our final round bench today, our bench will be presided over, or their case will be presided over by presiding Justice Maria Stratton of the California Court of Appeal, presiding Justice Helen Bendix of the Court of Appeal, and retired Associate Justice Stephen Perrin, all of the California Court of Appeal, Second Appellate District. And we thank these judicial officers for taking part today. Today's case is the case of People versus Peter Prescott. Mr. Prescott is represented by Team 2, Vladimir Mikhailov and Margarita Peralta Lee. Ms. Lee will handle rebuttal on behalf of appellant. The respondent, State of California, is represented by Sean Silverman and Deshaun Carter. Any questions before we proceed? Each of you has a total of 15 minutes. Seeing no questions, we will proceed. Mr. Mikhailov, you may begin.
Good morning, Your Honors. May it please the court. Vladimir Mikhailov appearing on behalf of Mr. Prescott. Mr. Prescott's conviction must be reversed because Mr. Flynn's had not was a testimonial statement, admission of which violated Mr. Prescott's Sixth Amendment right to confront witnesses against him. The admission of testimonial hearsay was prejudicial and is a reversible error because people are unable to prove beyond reasonable doubt that the error did not contribute to guilty verdict. My colleague, Margarita Peralta Lee, will brief this court explaining that the trial court failed to adhere to Civil Code of Procedure 231.7, resulting in prejudicial error. The prosecutor failed to explain how the presumptively invalid reasons he provided affected their case. The court must reverse Mr. Prescott's conviction because prejudicial error towards Mr. Prescott during the jury selection. Mr. Prescott has a Sixth Amendment right to be confronted with witnesses against him. The right to confrontation is firmly rooted within Constitution as the Founding Fathers contemplated and reflected the egregious errors committed in the past. Here, Mr. Prescott was denied that right because Mr. Flynn was not present at trial. Mr. Prescott was not given an opportunity to cross-examine him. The Supreme Court has explained in Crawford versus Washington 2004 that the testimonial statements are not admissible under any circumstances. However, the court did not explain what testimonial statements were. Later in 2006, in Davis versus Washington, the Supreme Court did provide us with the responses, with the definitions of what testimonial statements is and what non-testimonial statements are. Generally, a testimonial statement is something that admitted during the course of an interrogation when circumstances objectively indicate that there is an ongoing emergency and the primary purpose is to establish or prove events for later criminal prosecution.
Mr. Mikhailov, would you agree that a spontaneous statement would constitute hearsay, would not constitute hearsay, and it would be admissible under the Sixth Amendment?
And Your Honor, no, the spontaneous statement would not be admissible, and it could be a testimonial statement.
Why?
Because testimonial statements are not admissible under Crawford. The Crawford did clarify that if it is a non-testimonial, if the statement is determined as non-testimonial hearsay, then the state rules evidence code would apply, and therefore there would be hearsay, and then the judge would need to either deny or admit a statement based on whether they believe that it is testimonial, apologize, whether it is a valid exception under California Evidence Code 1240 in this case.
I have a question on that. Why is body language a statement for hearsay purposes? Is it? And especially here where the nod of the head was in response to a leading question by a deputy.
Your Honor, the statements can be defined under California Evidence Code 225, that because a nonverbal communication can also constitute as a statement. Here, a leading question was asked by the deputy regarding the identity of the possible assailant.
Why isn't that interrogation for criminal investigation purposes?
Because the law enforcement has already received information regarding the identity of the assailant, and they have already responded to the scene. They secured the scene. They knew who the assailant was, that there was no further need to deal with that specific issue anymore. So that makes those questions by Deputy Tyler specifically investigatory, where he is attempting to establish the past events, past facts for possible later prosecution.
Are there any circumstances under which this questioning would have been allowed under the Sixth Amendment?
No, Your Honor. The reasons here is because the emergency has passed. The 911 call has been made, and the police assistance has been secured.
And is that the only reason that the statement would have been allowed if the emergency had still been ongoing?
The case law does specifically indicate that the ongoing emergency does not necessarily make the statement non-testimonial. So, for example, here.
Oh, sorry, I interrupted you. Forgive me.
Thank you. Here, the major emergency, the safety to Mr. Flynn and the injuries that he obtained, received, those are being dealt with. The medical personnel is on scene, law enforcement en masse surrounded the scene, everyone's safe.
I guess, Mr. Mikhailov, that's my question, is that once the police arrive and the EMTs are there, that happens in most cases when you get a statement like this. And so it seems like that really isn't very relevant to the discussion.
I disagree, Your Honor. And that is specifically because Mr. Prescott was not in the area anymore. He was not a threat. And when the Deputy Tyler did ask
But how do they know that?
Because when Deputy Tyler was asking questions, he didn't ask whether who the assailant was, or I apologize, what the assailant was wearing, whether he had a weapon, where did he go. Those seem to be more pertinent questions rather than confirming the identity. If deputies were so concerned with the ongoing emergency, danger to public, for example, or danger to Mr. Flynn, or danger to the EMTs on scene, then it would be much more important to find out what the assailant was wearing, what weapon were they carrying, where did they go.
And let me ask you, would this, why doesn't everything you're saying, well, I'll let you finish your argument. Go ahead.
May I ask one question? The nature of the injury here was not benign. He was bleeding from he had trauma to his head, and there was blood, and he had just come back from almost an unconscious state. Why isn't this like the case law that says when there's an emergency on the part of the victim, the deputies asking questions to determine what the victim needs and whether the public also is potentially at risk with respect if the suspect is not caught yet?
Well, here again, Your Honor, simply because Deputy Tyler, he did not, when he asked the question, he was eliciting information to confirm identity. And no other deputies were asking Mr. Flynn any kind of questions regarding where did the assailant go. There was no hot pursuit. There was no active search for Mr. Prescott. That the facts indicated on the records indicate that Mr. Deputy Tyler arrived on scene. He did not see the injuries. He only saw that there's a bandage was placed on Mr. Flynn's head. And then he attempted to ask open-ended questions, and he received no response. And then when Deputy Tyler asked Mr. Flynn whether there was who was the assailant, as far as the specific question was asked, was this Porky, which is a moniker for Mr. Prescott. And the only response was 2 or 3 head nods in the affirmative. And all this while, the Mr. Flynn is being treated by medical personnel. This conversation, this questioning was allegedly caught in body cam footage, but later when reviewed, that was not visible.
So is your argument whenever, I'm sorry, I heard something else. I don't want to interrupt anyone. May I proceed, Madam Justice?
Yes, of course.
Okay, thank you. So under your argument, as long as there's medical personnel there, it could never be, any kind of questioning by the officer would be testimonial for purposes of criminal investigation. Is that your argument?
No, not quite, Your Honor. Not just because the EMTs are there, but it's the purpose of the questioning has shifted. That it went from providing assistance, providing police assistance, securing the scene, providing safety, providing medical treatment. It shifted from the securing police assistance to now establishing past facts. And the very important factor here is that the officers' questions were to establish facts rather than just deal with an emergency. That primary purpose of the questioning is a very important factor when determining whether the statement is testimonial or non-testimonial.
Thank you.
Now, the prosecution has failed to also exercise their due diligence to secure Mr. Flynn's presence at trial. Witnesses unavailable if prosecution has exercised reasonable diligence, but has been unable to procure his or her presence by court process. And this is Evidence Code 240 and People Andrade versus Andrade 2015. Now, there's no specific standard for to prove due diligence that prosecution must reach, but it's a combination of factors. Here, the prosecution, with unlimited access to law enforcement, did not attempt to find Mr. Flynn. There was no subpoena, no active search, no body attachment, just a text message and a call And it was not just a regular call, it was a call through an internet app. I believe it was called as WhatsApp. And the deputy, during his testimony, I believe it's page 463, he specified that the number appeared to be from Mexico. However, because this is an app and this is voice over IP number, then, Mr. Flynn could have been in the next room. Law enforcement nor district attorney's office attempted to locate or even issue a formal subpoena.
And what has that got to do with whether it violates the Sixth Amendment or not?
But
I'm guessing that if they had made an effort to get Mr. Flynn and were unsuccessful, you'd still be making your argument under the Sixth Amendment, right?
Yes, Your Honor, but it is important that we underscore that not only Mr. Flynn was unavailable, it also appears that prosecution did not do their due diligence to bring Mr. Flynn in.
Well, how is that relevant to your Sixth Amendment argument? Makes it a worse violation?
Well, it's a combination of factors, because now not only Mr. Flynn was not present, it is testimony of a law enforcement officer that enhanced a statement of an unavailable witness.
And how does that relate to the Crawford analysis under the Sixth Amendment?
It does not directly relate, Your Honor.
So why are you bringing it up?
I believe I'm a little bit ahead of myself because I am looking towards a reversibility argument.
Okay.
As I am very close to be out of time, Your Honor.
Okay, great.
When it comes to reversibility under this constitutional error, the burden is on prosecution to prove that absent the had not, Mr. Prescott would still be convicted by the jury, but that this case would result in the same, or this trial would result in the same outcome. And this standard comes from Chapman versus California, 1967. Here, the Flynn's had not, or the admission of the had not, was a violation of Mr. Prescott's constitutional right to confront witnesses against him. The victim's had not is a powerful corroborative and persuasive evidence against Mr. Prescott, and its impact was further magnified by deputy's testimony. May I finish my closing statement?
Yes, go ahead.
The court must review the record as a whole, whether the admitted evidence, it would result in the conviction beyond reasonable doubt. The other evidence is simply not enough. The admission of Mr. Flynn's had not violated confrontation clause because it was testimonial under Crawford and Davis and Cage. Prescott has no opportunity to cross-examine Mr. Flynn, and this error is reversible.
Thank you, Mr. McCullough. Ms. Peralta-Lee, you've reserved 3 minutes for rebuttal, so your initial remarks are 12 minutes, and you may begin.
Good morning. May it please the court. My name is Margarita Peralta-Lee, appearing for the appellant, Mr. Peter Prescott. I will be addressing the juror selection issue under California's Code of Civil Procedure 231.7 and the improper dismissal of prospective juror number 8, which is prejudicial per se. The judgment must be reversed because the trial court, improperly denied Mr. Prescott's objection to the prosecution's peremptory challenge as statutorily required under Section 231.7. Your Honors, this issue ultimately comes down to one of statutory adherence, the failure to not only adhere to the letter of the law, but also the spirit of the law. As recognized by this very court just last year in People v. Hinojos, California's legislature enacted Section 231.7 to establish a new, more robust process for identifying unlawful bias in the use of peremptory challenges during jury selection, because the Batson-Wheeler framework just simply wasn't cutting it. Here, the people made a peremptory challenge to excuse the only male Hispanic juror on the veneer at their very first chance they had to use a peremptory challenge. The intent of
Ms.
the
Peralta-Lee, let me ask you something that comes up a lot, which is in this case, you have a Hispanic defendant and a Hispanic victim. And so why does that matter? Both of whom were male. So why does it matter that this Hispanic juror, male juror, was also kicked off the jury?
Yes, Your Honor, it matters because even the use of a peremptory challenge against a single peremptory challenge against a juror that may potentially be seen or by an objectively reasonable person to be based on race, in this case, in rate of race, would violate my client's constitutional right to an impartial jury. And the intent of the legislation in enacting Section 231.7 was to address this particular issue that was not properly identified or could not be properly addressed with the prior Batson-Wheeler framework for
And why should we apply it in the case here where race didn't seem to be that relevant since both the victim and the defendant were the same race and the same gender?
Your Honor, regardless of the composition of the witnesses, the defendant, and the identity of the victim, any view or anything that may deem the court's process to be illegitimate or that may contribute to the court's process as deeming prejudicial, even if the composition of the victim and the identity of the victim and the defendant are the same, it wouldn't take away from the juror composition reflecting any potential bias when trying to eliminate the only potential juror of a different race. Even if the eliminated juror was of a different race than the victim and the defendant, it wouldn't help the courts, or it would defeat the purpose of the Section 231.7 in trying to prevent this unlawful bias, whether conscious or unconscious.
So that was going to be my next question, was if your client had been Caucasian or white, I guess, and the victim was white as well, you would still be making this argument. Is that correct?
That is correct, Your Honor.
I have a question, but it's on a different subject. So I want you to, I want to talk about the standard of review here. I have a question.
Oh, yes, Your Honor.
As I understand it, it's de novo under the statute, right?
Correct, under subdivision J of the statute, Your Honor.
What does that mean where the trial court's own observations, according to the statute, rebut the presumption of bias? What does that mean? You know, if you were sitting in our shoes, how do you apply that standard?
Yes, Your Honor. So under the standard of review that is statutorily required for your reviewing court to review the trial court's findings, you are to review their findings de novo with applying substantial deference to the trial court in the evidence that they were able to admit to the record. Now, there is a limitation that the statute doesn't apply both to your court and to the trial court. For your purposes, you are supposed to review the trial court's findings for substantial evidence in what they were able to record and to get on the record. And then at the trial court level, they were supposed to only apply their likewise, they were only supposed to rely on the prosecution's reasons given for their peremptory challenge, and not rely or impute any of their own beliefs for the reasons given to challenge the potential juror number 8.
Thank you.
Thank you, Your Honor. So here, the statute was, the trial court mostly adhered to the statute until it came to rebutting the presumptively invalid reasons that the prosecution gave when they, as statutorily required, for dismissing prospective juror number 8. They did give a variety of reasons, 2 of which fell under, were identified as presumptively invalid under subdivision G1 of the statute, and that was the prospective juror's demeanor, their inattentiveness, and lack of eye contact. Now, the trial court adhered to the statute by confirming these reasons, independently confirming through their own observations, but they did not complete the rebuttal of the presumption because they did not ask, or neither did prosecution give explanation why these reasons matter to the case at hand. And it has been found by both this court and in the 6th District with People v. Ortiz, that there is a two-step process to validly and properly rebut the invalid presumptions given by the party doing the peremptory challenge. Here, that was not completed. Because it was not completed, we ask that your court find that an error was made in allowing these to be, in denying the defense's objection to the peremptory challenge. And under the statute, any error is deemed prejudicial, and the judgment must be reversed for that reason. Excuse me. Also, as I had mentioned before, the intent of the legislature, and as I had mentioned, the spirit of the law, was to establish a more robust process for challenging these, for properly analyzing and having a more thorough analysis and getting more on the record as to why a juror may be to addressing subconscious bias and why a juror may be dismissed. Here, there wasn't enough on the record to establish why the trial court, to properly establish why the trial court would go ahead and dismiss the only male juror on the panel when excuse me. Here, the trial court did not get everything on the record as needed by the statute. They needed to follow this two-step process as explicitly required by the statute. In enacting the legislation, it made it mandatory for this two-step process to include the prosecution's reasoning for explanation for why the reasons given matter to the case at hand. And they simply did not do that. Even in People versus Ortiz, where it was recognized that they didn't even get to the court of making or confirming observations, but they did reinforce the fact that it didn't matter how the explanation is given. The counsel could have given explanation. It mattered whether an explanation was given, and none was given in this case. That in itself was an error, should be found to be error as violation of the statute. This is a very recent, a newer statute, and I understand that the Batson-Wheeler framework had been in play for many years, but it has been identified and recognized in the U.S. Supreme Court, by the California Supreme Court, and many of our district courts, that the Batson-Wheeler framework was still allowing a lot of subconscious bias, unlawful bias, and improper removal of jurors based on race. And that was reflected in the enactment of AB 3070 that enacted the statute. My client deserves a fair and impartial jury, and that opportunity was not given to him when the prospective juror number 8 was dismissed.
Thank you, counsel.
We'll now hear, thank you, counsel for appellant. We'll now hear from Mr. Silverman first on behalf of the respondent. You have 15 minutes.
Good morning, Your Honors, and may it please the court. My name is Sean Silverman, and I, along with my co-counsel, LaShawn Carter, represent the respondents, the state of California. I will be addressing the peremptory challenge, and my co-counsel will be covering the confrontation clause. Because the appellant will not prevail on either, we ask that you affirm the trial court's ruling. The appellant claims that we should look to the spirit of the statute, but the court in People v. Guzman cautioned that such an intent doesn't justify erroneous construction, which is what the appellant asks for today. Peremptory challenges are one of the oldest and most established jury selection procedures. They allow both parties to shape the jury and exclude jurors who they believe will harbor prejudice or will be neglectful in their duties. Using proper jury selection procedures is exactly what the prosecutor here was doing in exercising a challenge against an inattentive juror. First, the prosecutor provided valid reasons for the challenge. Second, even if some of the reasons are presumed to be invalid, as the appellant contends, the confirmation of the trial court and the explanation of the prosecutor easily overcame that presumption.
And what was the explanation of the prosecutor? Because I didn't get one. I didn't see it.
Your Honor, so the appellant mentioned that inattention was one of the reasons given. But actually, on page 10 of the record, the augmented transcript, the prosecutor clarified that the prospective juror's lack of eye contact and courtroom conduct, two reasons, displayed that they weren't paying attention to the process, which is an explanation as recognized under the statute.
But he didn't, the prosecutor didn't try to kick off the juror that was sleeping during the break.
Your Honor, so under subdivision J, we aren't supposed to consider, we weren't supposed to speculate on reasons that aren't given or confirmed on the record. And this reason was something that wasn't brought up by the prosecutor or the trial court. It was brought up by defense counsel.
And why does that matter?
It wasn't
defense counsel that brought it up.
This is because it wasn't confirmed on the record. And as you mentioned, while the prosecutor didn't excuse this juror, they didn't have an opportunity to. On page 11 of the record, the defense counsel, once they received the ability to challenge this juror, immediately excused juror number 10, who they believe were being inattentive. Thus, the prosecutor had no opportunity to challenge this juror.
I have a question, but again, it's moving on to, I want to get back to something your opponent said. You said that this statute is grounded in a very fundamental rights of picking jury selection that has a venerable history. So my question is, this statute strikes me as an attack on some of that venerable history because it didn't address implicit bias. It didn't allow implicit bias to be addressed properly, putting it differently. When I read this statute, it seems to me that the legislature wanted to make this, make it almost judge-proof. It restricted a lot of the discretion a judge would normally have in the jury selection process. Isn't that relevant here?
So, Your Honor, regarding that deference and restrictions the statute imposes, the opposing counsel mentioned that the review is de novo. And while that's true over questions of the law, reviewing under an express confirmation, as the trial court did here, it confirmed the reasons given by the prosecutor, is done under the deferential standard of substantial evidence. And here, the trial court met that standard. That's especially true because an appellate court only has access to the record, and here, not even the full record. And thus, they're unable to observe the demeanor and conduct of the juror at the time, which were reasons given for the excusal of this juror.
But in every other kind of, almost every other kind of case, we as an appellate panel don't make credibility determinations and so forth. We defer completely to the trial court. So what's our role in de novo review under this statute?
Of course, Your Honor. So your role in de novo review is to determine the scope of the statute and whether the prosecutor's reasons and explanation comply with that statute. So I want to talk a bit more about what the statute entails.
Isn't our review to review for the de novo considering the totality of the circumstances, but we're not allowed to infer things if the trial judge didn't make those, that whatever we're trying to infer, and so forth. What does that mean here? What are the totality of the circumstances here that you say we, exercising our de novo review, should affirm?
Of course, Your Honor.
So I'd like to hear that discussion.
So regarding the totality of the circumstances, reviewing courts, as per People v. Hinojos, focus on the nature of the case, the parties, and most importantly, the voir dire proceedings.
Mm-hmm.
And because the trial court is in the best position to gather those facts, the appeals court should defer to the findings of the trial court as they appear on the record. And let me talk about some of those findings. So here, the alleged victim was a Latino male, and a witness for the prosecution was also a Latino male. And that's something that the court in People v. Jimenez thought was relevant in finding that their bias could not be found as a factor in the challenge. And that was something that Your Honors mentioned in a question to opposing counsel, the fact that it's relevant that the victim here was a Latino male. Additionally, there's also...
But here's my question, and I'm following up on Justice Stratton's question. Some of the discussion was that it wasn't prejudicial because they're the same ethnicity. But do you have to show prejudice at all once there's an error in the way the juror was selected, going back to your process point? I'm trying to understand the relevance, and Justice Stratton was exploring it in the prior discussion.
Of course, Your Honor. So I believe what you're referring to is the case by People v. Caparota, which could have prevented the court from proceeding to consider the totality of the circumstances if the procedure was not followed. However, the court in Caparota acknowledged that under subdivision G of the statute could be read as requiring the totality of the circumstances analysis for any of the remaining valid reasons that were given in support of the peremptory challenge. For example, nothing in the text of the statute explicitly states that the existence of a single conclusively invalid reason, one that kind of failed the confirmation and explanation requirements, requires the objection itself to be sustained. In fact, the text of the statute reveals the opposite. So under subdivision E, which is another set of presumptively invalid reasons, the statute deems the challenge itself to be invalid. It says failing to rebut that presumption results in an invalid challenge. Whereas under subdivision G, merely the reasons are presumptively invalid, not the challenge itself. Therefore, the court is free to consider the remaining facially neutral reasons in the totality of the circumstances analysis.
Thank you.
So I want to make some other points about that totality of the circumstances analysis. The court also importantly considers whether there's a pattern of strikes against this cognizable group, here, Latino jurors. And there's no indication on the record that the prosecutor used peremptory challenges disproportionately in this or any other case. In fact, on page 11 of the augmented record, the judge explicitly rejected any such suggestion. Furthermore, the court...
And why is that important, counsel?
Your
That he
Honor,
didn't do it before?
Your Honor, the fact that this wasn't a pattern of exercising peremptory challenges against Latino jurors goes against a finding of bias as recognized.
But it doesn't require a pattern, does it?
Your Honor, while a pattern isn't required, it is one of the elements, circumstances by which a court can consider the totality of the circumstances and thus determine whether a reasonable observer would have a substantial likelihood of viewing bias as a factor in the challenge. For example, if the prosecutor had issued peremptory challenges against 5 Latino jurors before issuing this peremptory challenge, then a reasonable observer would have a higher likelihood of viewing bias as a factor in this challenge.
But as a trial court said, there weren't that many Hispanics in the veneer to begin with. So how could you show a pattern if there weren't that many to begin with? What if there were only one and he happened to kick the one that was in the veneer?
Your Honor, so there wasn't just one Hispanic juror in the veneer.
No, but my hypothetical is, what if there was just one? Would you say that because there's no pattern that you should find that it was fine?
Your Honor, a pattern would be evidence of bias, but the lack of a pattern doesn't mean that there's insufficient evidence to show that there wasn't bias. The prosecutor's reasons in exercising the peremptory challenge are also considered at this totality of the circumstances stage. And here, I want to talk about those reasons. First, the prosecutor gave the reason that the juror had left the courtroom with court papers and had walked in during a break. Additionally, the juror was lacking eye contact, and the juror had brief responses. The trial court...
Can I just interrupt you a second? Because I think the record reflects that the judge said he never told the jurors they couldn't take the paperwork out. And the fact of the eye contact seems to be an illegal reason under the statute. So, and talk to me about how the prosecutor actually related those reasons to the issues at hand. Why they
Yes, Your Honor. So it seems like you have 2 points. First, addressing the prosecutor's reasons, and second, the explanation. So here, you mentioned that the trial court didn't actually give an order that explicitly prohibited jurors from taking things out of the courtroom. However, the trial court did note that it's an order he would have given if he had the foresight to. So it is notable, especially since this juror was...
Why is that notable? If he didn't tell the jurors what to do, why is it notable?
It's notable because it means that this juror wasn't paying attention to what the other jurors were doing, since no other juror had walked out with courtroom papers.
And why is that relevant to kicking a juror off the panel, that he's not observing what everybody else is doing?
Your
when
Honor,
there has been no instructions on that issue.
Your Honor, it is relevant to the case, and the trial court noticed this on page 10 of the transcript, that it relates to the juror's ability to pay attention to what other jurors are saying in deliberations, and thus pay attention to the process as a whole. In fact, in People v. Hernandez, the court recognized that inattention is a race-neutral reason that any prosecutor would legitimately exercise a peremptory challenge for. And so I want to get to that explanation. That explanation was inattention to the process. That was something that the prosecutor said on page 9 of the augmented transcript. In Ortiz, the court held that the proffering of any explanation regarding why the asserted demeanor mattered to the case fulfilled that requirement. And thus, it fulfills this low bar. No California court has held that an explanation under subdivision G of the statute has failed to meet this low bar. And this is because there's more of a focus on the confirmation requirement, which is undisputably fulfilled here, rather than the explanation requirement. And that can be seen in the People v. Guzman and People v. Aguilar, where the Court of Appeals didn't even consider whether there was an explanation required. And it's worth noting, as I mentioned, that this presumptively invalid reason is different from under subdivision E, which requires clear and convincing evidence to overcome that presumption. Your Honors, I see that I'm out of time. I may briefly conclude.
Yes.
Your Honor, Because no reasonable observer would have a substantial likelihood of finding that race was a factor in a challenge, we ask that you affirm the trial court's decision to deny the objection. Thank you.
Thank you, counsel. Mr. Carter?
All right. Can everyone hear me okay?
Yes.
Good morning, Your Honors. My name is Deshaun Carter, and I'll be representing the respondent, the state of California. May it please the court. The Sixth Amendment does not bar statements used to assist officers in addressing an ongoing threat. Here, the objective circumstances point that there was an ongoing emergency for 3 reasons. First, the scene of the incident that officers responded to was out in the open, and uncontained. Secondly, Deputy Tyler's questions lacked any formality of a formal interrogation. And lastly, Your Honor, when the questions were asked, the defendant's whereabouts and motives remained unknown throughout the entire questioning. And even if you do find this error was harmless beyond a reasonable doubt. Your Honor, the prosecution presents evidence that points in one direction, the defendant's guilt. For those reasons, we ask that you affirm the trial court's verdict.
I have a question first. I'd like you to address whether this sequence of events supports a spontaneous statement exemption to hearsay under 1240.
Yes, Your Honor.
It's not obvious to me that this was that he was in the excitement of the perception, using the statutory language, given that he was unconscious, coming out of unconscious, but still in an unresponsive state. How does that fit within the hearsay exception to begin with? But before we get to confrontation, a constitutional question, it's not clear to me that this even fits within the hearsay exception. Explain to me why I shouldn't be concerned, please.
Yes, Your Honor. And I'll answer your question in 2 parts. First, in addressing the California Evidence Code here, 1240, which presents a 2-part test into whether or not spontaneous statement. 1, it needs to describe an event that was perceived. And additionally, Your Honor, and importantly to this case, the declarant must be in a stress of excitement that was caused by such perception. And this leads me to my second point, where the perception here was the assault by the defendant. Here, Your Honor, the victim here, Mr. Flynn, was suffering from severe injuries here. And he was still under the stress of excitement from the assault in this case. Thus, his head nod here fits squarely into the California spontaneous statement exception. And because this falls under a hearsay exception, we can finally get to the confrontation clause analysis. Now, Your Honor.
I'm still on my first subject. I just want to make sure I understand. Does it make a difference here that the video did not capture the head nod? We couldn't see the head in the video. And secondly, and this relates to why I'm noting that, is what a court still has to consider whether it's trustworthy. The admission of the purported hearsay is trustworthy. Here you have a bunch of medical personnel moving around. His head could have been moved around because one of the doctors or one of the EMTs did something to make him to move his head or to observe a certain part of his head. Explain to me why I should feel that the circumstances here were trustworthy enough, assuming you're right in what you said before, that this even fits within the hearsay exception.
Yes, Your Honor. And I want to clarify briefly in the sequence of events that occurred here. Your Honor, Deputy Tyler's question and when the head nod was elicited, it wasn't during when paramedics were on the scene of the crime. Your Honor, the reporter's transcript is clear on page 283 that Deputy Tyler asked Mr. Flynn, was it Mr. Prescott, before paramedics arrived. So that goes into saying that the scene itself wasn't secured, and thus the statement elicited Mr. Prescott or Mr. Flynn wasn't receiving any medical attention when he elicited the head nod here. Additionally, Your Honor, the trial court, the judge made a finding that after watching the body cam footage, he could see that there was a head nod elicited there. Your Honor, because Mr. Flynn was experiencing severe injuries here and was continuously under the stress of excitement, along with the scene not being secured, the defendant's whereabouts being unknown, this falls under the spontaneous statement exception. And additionally, it is non-testimonial, as the emergency here was still ongoing. And in getting to this emergency, Your Honor, the Supreme Court case in Michigan v. Bryant, it's clear that when a victim is still in a severe medical condition, they would not have the primary purpose of proving past facts relevant to trial. There, Your Honor, in Michigan v. Bryant, officers were responding to a victim who suffered from a gun wound and was profusely bleeding, similar to our case where the victim, Mr. Flynn, was severely bleeding from the top of his head. There, they held that the statements elicited from the victim were non-testimonial, primarily because of his injuries and because the defendant's whereabouts remained unknown. Additionally, Your Honor, the scene of the emergency situation cannot narrowly focus on the scene of the incident itself. Michigan v. Bryant is clear as here as well. When a defendant is at large and can continue their criminal conduct, as such as this case, where the defendant was at large with a deadly weapon, that expands the emergency scope to not just the temporary safety of the victim, but to the police officers and the public at large. Your Honor, this isn't like the case in Davis v. Washington or Hammond v. Indiana, where their officers were responding to a domestic violence incident. There, Your Honor, the scene in which officers were responding to was contained in a home. And additionally, the defendant's whereabouts were known when officers arrived. Here, Your Honor, due to the nature of the incident, an assault with a deadly weapon, this shows that we don't know whether or not Mr. Flynn could have or was the only victim in this case. And that because it's not a domestic violence incident, that expands the zone of victims that we are looking for, and thus goes towards showing that this was an emergency situation that officers were responding to. Now, in getting to the perspectives of Deputy Tyler and Mr. Flynn, as explained before, because Mr. Flynn was suffering from severe injuries, he likely did not have the primary purpose proving past facts relevant to trial, but rather to help officers in responding to an emergency. In Deputy Tyler's point of view here, Your Honor, confirming the identification of a suspect did two things in addressing the emergency. First, it allowed the officers to confirm whether the suspect they heard about on the radio was the same perpetrator still at large in a homeless encampment at the dead of night, which severely limited officers' visibility here. And secondly, Your Honor, confirming the identification of a known suspect allowed officers to assess the threat and figure out how to effectively address the emergency situation and thwart any ongoing emergency. And lastly, Your Honor, because the defendant's whereabouts and motive remained unknown throughout the entire investigation, officers are not certain whether or not Mr. Prescott either remained at the scene in the large homeless encampment or was continuing his criminal conduct. Your Honor, these circumstances objectively point that the primary purpose of the questioning was not to prove past facts relevant to trial, but to address an emergency that did not squarely stay at the scene of the incident, but rather extended beyond the scene of the incident to the public at large and to officers at the scene. Now, even if you do find this an error, Your Honors, this error is harmless beyond a reasonable doubt. The standard here is outlined in Chapman v. California, the federal harmless standard. There, Your Honor, we ask whether the error that occurred at trial was surely attributable to the verdict at case. In other words, did the error affect the verdict? Here, Your Honor, the head nod merely proves one thing: the identification of Mr. Prescott. However, Ms. Shannon's testimony not only proves that, but more, Your Honor. Ms. Shannon's testimony indicates that not only Mr. Prescott was there at the scene, but he was the primary assailant of Mr. Flynn. And also, Ms. Shannon's testimony does not stand alone in this case. Your Honor, Ms. Shannon's testimony is corroborated through the cell phone tower data elicited in evidence, and additionally, the DNA evidence found on the very weapon, the bat here. And lastly, Your Honor, we also have the medical records that were admitted into evidence, and more importantly, the very 911 call that Ms. Shannon called to call officers onto the scene of the incident. All of these pieces of evidence not only strengthens Ms. Shannon's testimony, but it proves what the head nod merely proves, that Mr. Prescott was the primary assailant and was at the scene of the incident. Your Honor, this case is similar to People v. Livingston, where there a similar confrontation clause issue arose. There, the California Supreme Court dealt with a confrontation clause error of the victim identifying the defendant. Here, Your Honor, we have a similar error. However, People v. Livingston found that as harmless beyond a reasonable doubt because the error in that case was merely cumulative of the other pieces of evidence. They already presented eyewitness evidence identifying the defendant. And here, Your Honor, Ms. Shannon cannot be seen as a mere eyewitness, but also a victim of Mr. Prescott's gruesome assault on Mr. Flynn. She was there throughout the first, the second, and third hits on Mr. Flynn at the entire scene of the crime. Here, Your Honor, the properly admitted evidence independently proves guilt beyond a reasonable doubt, and reversal is unnecessary because the verdict would have inevitably been the same absent the error. Your Honor, due to the error merely being cumulative of the other pieces of evidence that was presented by the prosecution here, the prosecution substantially meets their burden of proving harmlessness beyond a reasonable doubt. Now, Your Honors, I wanted to address a question that was asked against my friends on the other side regarding the unavailability of the declarant, Mr. Flynn. And I just want to quickly respond that not only is this not an issue that is at trial, but also the defense failed to preserve this issue to be brought up here. The only issues that are relevant for this court is to decide whether or not the primary purpose of the statement was either testimonial or non-testimonial. And additionally, if it was testimonial, whether or not this error was harmless beyond a reasonable doubt. Now, Your Honor, if there is any other questions reserved for the judges or from Your Honors here, I'll be glad to answer either them on the confrontation clause here or the harmless error. But
I don't have
I don't
any
see any
questions.
questions. So thank you, counsel.
then I'll just quickly close. Your Honor, the confrontation clause error here there's no confrontation clause error here because the statement squarely falls on non-testimonial statements. And even if there was an error, Your Honor, the prosecution presents substantial evidence for an inference of guilt. For those foregoing reasons, we ask that you affirm the trial court's verdict. Thank you.
Thank you,
Thank
Mr.
you.
Carter. Ms. Peralta-Lee, you have 3 minutes of rebuttal.
Hello, Your Honors. I will be addressing points that opposing counsel made with regard to, I'll start off with regard to the juror selection issue. Opposing counsel put a lot of weight on the dismissed jurors' inattentiveness, and they relied too heavily on the fact that the reason given was by prosecution was that paying attention was not helpful to the process, but they were not being specific. Prosecution was not specific to how the inattentiveness or lack of eye contact was relevant to the case at hand, and that is what the statute requires. This is why statutory adherence is very important, because this was made explicitly mandatory under the statute when it was enacted. They also relied heavily on the court's confirmation, but that is not where the procedure requires. The law was not followed completely because explanation was required, and that was not given. The people also referenced People v. Hinojos, which was also a case by this court. But in People v. Hinojos, the objection was sustained, and it was the reverse, where the court applied the analysis for sustaining an objection, and that does not apply here because the objection was denied. Addressing valid reasons does not preclude. Counsel also made a point that prosecution gave reasons and factors that were not presumptively invalid. And while we do concede that that was made, that does not preclude the court from having to analyze and go through the procedural requirement to address the presumptively invalid reasons, which was not completed, and they were not validly rebutted.
Ms. Lee?
Yes, Your Honor.
The test for us on review is totality of the circumstances. Is your argument that once there wasn't an explanation for two presumptively invalid reasons, but also observed by the trial court, that's the end of the inquiry? We don't look at anything else?
No, Your Honor. My argument is that that is not the end of the inquiry, and the trial court was, in order to adhere to the statute, was supposed to get an explanation from the prosecution to explain why those reasons, those presumptively invalid reasons, matter to the case at hand against Mr. Prescott. And those explanations—
It sounds like you are saying that's the end of the inquiry, because you're just repeating what you said before.
Oh, my apologies, Your Honor. No.
I apologize. I'm trying to understand what totality of the circumstances means here.
Yes, totality of circumstances with regard to the— my apologies, Your Honor.
Did you finish your sentence?
Yes. Where totality of circumstances with regard to how an objectively reasonable person may have viewed these factors as being these reasons as being a factor for
the exercise of the challenge.
Yes, for the exercise of the challenge.
Thank you. You answered my question. Thank you.
My apologies, Your Honor.
Have you concluded, counsel?
Just quickly, Your Honor, there was prejudicial error both in the juror selection phase of the case, and the prosecution failed to address failed to identify any errors that were harmless beyond reasonable doubt. Our client is facing constitutional violations, and this is why the judgment should be reversed and remanded for a new trial. Thank you.
Thank you. And thank you all for your arguments. We're very well presented. We will take this matter under submission and be in a temporary recess.
Justices, if you can turn off your cameras and your mics for your conference.
You can't do that for us. Okay. Okay.
Okay, so the three justices are now in conference, and we shall take a little break from that. Congratulations to both teams. And now it's our time to thank everyone for yesterday. We hosted 26 competitors, 14 judges, and many observers from all over the state and even beyond for 2 exciting rounds of oral argument that all took place on Zoom. As much as we loved doing the Traynor in person before 2020, doing the Traynor virtually on Zoom has really improved the affordability and accessibility and inclusivity of the competition. We are looking into ways to bringing it back live, but I think the Zoom worked out for so many of us who came from all over the state. And I wanted to say that a huge part of our success this weekend was due to our host school, the University of West Los Angeles School of Law, Robert Brown, President, Jane Frickberg, Provost and Dean, Troy Brown and Jesse Aldava, Mauricio Cana, and Hamid Taf all worked with us both virtually and on site at the campus. Also at the campus, live and in person, we had our able and dedicated student and alumni bailiffs, so we thank them.
Yeah, David,
Justice Perrin. I'm going to mute him. Sorry, I was able to do that. So we wanted to thank our bailiffs and thank you to all our judges who volunteered their time and energy and expertise to this event. Some of them are in the room today, so we can thank you personally. The Traynor was made possible by a very generous grant from the Gisnet Mandel Moot Court Trust. Special thanks to Patrick and Ingela Pigot. And thank you to Stuart Esner of Esner, Chang, Boyer, and Murphy. They are a gold sponsor. They underwrote the lunches for the judges.
Is trying
on our website, which is traynormootcourt.org, you will be able to find all the information about the case and information about the Traynor, the list of winners, as well as past winners, and a video of this final will be available there as well. And that will be going up in the next few days. So check that out. We have an official competition program as well. So you can read about all our judges, see what schools competed, and information about the competition itself. So now we have some awards to announce before we announce the winner of the final. We have first the Roger J. Traynor Award. That is going to be announced by the justices when they return. That is first place to the team presenting the best oral argument in the final round, and second place to the other team in the final round. The best brief is named after the Gisnet Mandel Trust. It's called the Gisnet Mandel Award. And the Best Brief Award goes to Kern County. The second place Best Brief is Berkeley. And third place in the brief competition is awarded to McGeorge. Next, we have the award for Excellence in Appellate Advocacy. This is the first place to the team with highest combined total, 50% brief, 50% combined oral argument scores from the first 2 rounds from among the schools in the top 50% on both brief and oral argument. And that award goes to Berkeley. And the second place award for excellence in appellate advocacy goes to Kern County. And the third place goes to McGeorge. Next, we have the Jeffrey Hall Wright Award for Best Oralist. When we post the commemorative program from this year's competition, you'll be able to read about Jeffrey Hall Wright, who is the person we have named this award for. There's a biography of him in the program and a photo, so please read that. This award is for the best oralist, and this year we have a tie. So we are awarding 2 Jeffrey Hall Wright Awards, and they will go to Grace Telford of McGeorge and Sean Silverman of Berkeley. We have individual merit awards for oral argument, which is for performance on Saturday, and those go to Benjamin Arcure San Joaquin, Deshaun Carter of Berkeley, Ryan Cochran of Loyola, Patrick Cully of Empire, Sonia Linares of Loyola, Monique Magdaleno of McGeorge, Marcus McMahon of Empire, Nia Mireles of Kern County, Bradley Rutledge of San Joaquin, and Jacqueline Uke of Berkeley. So congratulations to everyone who won an award, everyone who participated in the Traynor this year, and we will return with our justices in a moment. Stay tuned.
Thank you so much for inviting all of us to participate today. It's a wonderful experience for us. So what we're going to do is we're going to start with Justice Perrin, and he's going to give his reactions to the arguments, and then we'll go to Justice Bendix, and then me, and then we'll announce our decision. So take it away, Justice Perrin.
Okay, Justice Stratton, I understand I can hold them in tension, and I will not announce any result other than just comment on the performances and the problem. Is that correct?
Great.
Okay. To the students, first of all, there's a platitude that usually precedes these things, which is, gee golly, weren't you all wonderful? Well, the fact is you were. I've heard many of these. I want you to grasp a little bit of the background on this. I have been retired for 3 years, and this statute came to life after I was retired. And I thank God that I was not on the bench when this statute came in effect. It drove me nuts reading it, and listening to your arguments made it clear to me that this is an incredibly difficult area that you have to address. And I think each of you enlightened me, because I came as an ignorant soul, other than what I received from the opinion from the briefs that you presented. As for the defense team, I think the appellants, I think you're really paddling upstream rather. This is an incredibly difficult point. It's a difficult topic, and the subject of CCP 237 is, I think, can only engender confusion to a public that needs certainty in trusting its law courts, which is at issue before us today, generally. For the record, right now, I'm only seeing the respondents' pictures. I don't see the appellants on screen. I trust that they're with us. Okay. My comment, and I'll be brief. No, I won't. I never am. I thought that the issue before us, both issues, the evidentiary issues and the jury selection issues, were both important and incredibly confusing. The statute should bring clarity to the rule of law, and this certainly 237, I think, is a confusing nightmare. That's me speaking 3 years off the bench. I never heard one of these cases. I was unfamiliar with the statute. Getting to the, I did read it before we went on the air. Also, I couldn't get my mute off, which was a problem that speaks strongly to my silence, which is, I'm not famous for being silent. So I'll tell you that you got lucky. Going first to the appellant team, as I said, I think you're paddling upstream in this case. Everything in this problem is so highly subjective. It tests the boundaries of what law is about. There's a certain certainty that the law is to bring to our society, and I don't think this helps it. You did. To the defense, to the appellants rather, with respect to the evidentiary issue, again, the vagary of it, what does a head nod mean? And what is hearsay and what is not hearsay? I thought you elucidated on the point well. Thank you. As to each of the parties individually, I think I will look you in the eye and say, Mr. McCulloch, that was a job well done. Ms. Lee, and the same to you. The subject of the evidentiary ruling is so vague. I was hanging on for dear life. I came as a blind juror to this case and was stunned by the ability that you had to clarify. Mr. Silverman, thank you very much for your discussion. I want to turn to the respondents. You had a stronger case. I think you had the better position to argue from. I thought your response to my colleagues' questions were excellent. On the point of jury selection, I remain pretty much as confused after having read the statute and now having heard you as I was from the beginning. I came as a blind man to this, and my sight was not restored. Mr. Carter, job well done. I thought both your organization and clarity were striking. And I thank you for that. And my comments are needlessly broad because I don't want to spend more time on this other than to give strong praise to you for taking an incredibly difficult topic and making something clear out of it, or relatively so. I'm going to defer to my colleagues and just leave it with my gratitude toward all the parties for their presentation on this very esoteric, very difficult topic. And Mr. Silverman, also, I want to thank you for your presentation as well. I hope if you have any questions of me, or if we have a general conference afterwards, I'll be happy to talk with each of you as a group. But thank you for the order. I'm not going to give you the result. I'll let you hang on tenterhooks as we move through the justices' statements. And I yield now to my colleague, Justice Bendix.
Okay, thank you. I don't want to be repetitive, but I share Justice Perrin's awe at the ability of people so fresh in the profession. I'm going to go to my 50th law school reunion this year, so you can get a sense of the differences we approach. We are different phases in our careers, and I look forward to all four of you aspiring to be a judge one day. It's the world's best job, and then you'll see how hard it is. and so I hope I live long enough to see it. So I start with that, and I don't want to repeat what Justice Perrin said. I think all of you did a good job working in the applicable case law, which is important. And I think that that's the first thing I would say. I think at this point, I'm going to go through each one of you separately, because I think Justice Perrin gave a very good overview of what a great job you all did. I'm looking now first at the appellants team, and I'm going to ask, forgive me, I have to see how it's spelled to pronounce your name, and you'll have to forgive me. Mr. McKelloff? Did I get it right?
Yeah, yes, that's very close, Your Honor. Thank
Okay,
you.
okay. Well, tell me how it's right. Tell me, I'm going to hear it right. Oh, okay.
Mikhailov.
Thank you very much. So I thought you did an especially good job working in the Superior Court law. And I think you parried with us on the questions because you went first. So you had the hardest job in some ways to figure out what's this going to be like, and here we're throwing a lot of questions at you on, as Justice Perrin said, were very difficult areas of the law. And if I may have two recommendations. One is I wouldn't say I disagree with the court, because some judges have egos and they don't like to hear that. So we don't. I know the people here, we understood what you meant, but I think I would put it differently. I think I would say, thank you for the question, and then proceed to disagree without saying you're disagreeing. That's what I would do. But that was my only suggestion. Then Ms. Lee, I thought you did a very nice job introducing your argument, because I think, as one of our colleagues likes to say, it's not a mystery novel when you write a brief, and an argument isn't a mystery novel either. So I like the way you told us what the issues are, where you're going. I also liked that your main point is that the statute is dispositive here. Whatever you think about the statute, it is dispositive, and you work that theme through your argument very well. You didn't have a lot of time in rebuttal on the, but yeah, okay, very good. Mr. Silverman, I thought you did a very good job parrying with us on questions, because we threw a lot at you. And I also, I share the same comments that Justice Perrin has, so I don't want to repeat them. Mr. Carter, I thought you really paced your argument well. And you clearly had in your mind what the points you wanted to cover. You figured that you have to save time for the questions because you knew you were going to get them. But you still were able to cover all the points in a logical sequence. And that takes a lot of good instinct. So you have the good instinct, as an attorney. And I thought you worked in the case law very well. And I think you picked up that where harmless error is relevant, you picked up arguing the facts, saying, okay, even if you don't agree with me on my hearsay argument, it doesn't matter. And here's why. And I think that you always have to have that in your back pocket if you can. If it isn't structural error, you have to have that in your back pocket. So I think you understood that. But all of you, all of you did. When I look at the four of you, I think the profession is in good hands. And I look forward to reading about all of you and your many successes. That's all I have to say.
Great. So I'll go through each of you. Mr. Mikhailov, you had no nerves. I thought that was great. And it was particularly great because you were the first one up, and you had no nerves. It was wonderful. And I thought you spent a little bit too much time explaining how the division of labor was going to be. It could have been a little shorter, and I was worried that you were going to not save enough time for your argument. So you didn't really need to do a summary. And that's a common problem with appellate lawyers, is sometimes they come in and they want to give us like a whole background, and we're like, no, we read everything. We don't need you to do that. So I would just put that on your radar. I thought you had I asked you a lot of questions, and I have to say to all four of you, both of these issues are really hard for judges. They drive judges crazy. when these issues come up, because they are so fact intensive, and you know, the law is just so developing all the time. It's so you all had two really difficult questions that you had to deal with. I thought you were great at responding to the questions that I threw at you. You did not seem to be fazed at all. And particularly at the end, when I started asking that question, you said, well, that goes to prejudice, my next point. And it was just wonderful how you just segged right into that without any kind of hesitation, or, you know, you didn't make me feel stupid for asking the question. You made it sound like, oh, you're one step ahead of me, Judge. Let me get to you. And that's nice when the judge doesn't go, oh, I was pretty stupid asking that question. You made it sound like it was a good question to ask at the time. So I thought you were really great. Ms. Peralta Lee, I loved your starting off with the letter and the spirit of the statute. You had a terrific command of the statute, absolutely terrific. And but you also circled back at the end of your discussion about the statute, you circled back to the spirit and did that as well. And I thought it was a terrific argument. Your rebuttal was a true rebuttal. A lot of people use their rebuttals just to talk some more, but you actually narrowed it down to the points you wanted to rebut. And I thought that was a terrific use of your time. Mr. Silverman, I thought your opening was terrific because you responded directly. You were a true respondent. You responded directly to the argument that we just heard. And I was very impressed that you started out that way, because I thought, oh, this is going to be a really good actual respondent to your response. You were really good at seeing between topics. You were seamless. It was terrific. When you did that whole thing about you had a really good differentiation between an explanation and a confirmation. That said to me that you had really thought about the statute and had kind of parsed it out in your own mind. And to put it like that, that's the kind of language that would end up in an opinion. It was really a well thought out discussion and parsing of the way you wanted us to look at the statute. But I thought, oh, that's a really good line. You know, if I were writing the opinion, I'd probably put that in there. So you just had clearly thought about it. I thought it was great. Mr. Carter, I thought you were, in a word, fabulous. Your argument was very structured. You spoke slowly and clearly on an issue that could be confusing to people that were not aware of it. You had a really good command of the facts. And as Justice Bendick said, you portioned your time very well. In fact, you had a little time left over at the end and you didn't pad your argument. A lot of people will do that. You just, like, you were right on time. You had a little bit left. You didn't try to pad it. You just kind of like said, I'm done here. If you have any questions, I'm done here. And then you closed, and that was the end of it. I thought that was very, it's what a pro would do. It's what a pro would do. When you brought up the issue of the unavailability of the witness, that issue, I was going to say something, but I was kind of like, well, maybe that was in the record and I missed it. But when you brought it up, I was like, thank God somebody like called him on that issue. I thought it was really great. I just think, I hope all four of you go into appellate work. It'd be such a great addition to the appellate bar.
Exactly.
And then I'm supposed to give our verdict, and our ruling is that we think that respondents team won the competition. So congratulations.
Well, that's very exciting. Congratulations to Berkeley for winning, and Kern County for being
Bears!
What's that?
Berkeley.
And Kern County for second place. What a wonderful competition. What an exciting final. And Professor Glassman, thank you for your bailiffing. And for the justices, thank you so much for joining us this morning. Professor Glassman, any final words on Traynor 2026?
Thank you to the competitors and to the bench for a fitting final round, and hopefully we'll reunite in Traynor 2027.